Hello, I'm Joseph R. Johnson. I've been a criminal defense attorney in Florida. I've practiced law for more than 25 years. I've been a Florida State Trooper. I've been a police officer in the state of Indiana. I've also been an assistant state attorney and an assistant public defender. I've been in private practice for more than 20 years. And one of the most common questions I get is people come in and say, oh, the police unlawfully arrested me, they didn't read me Miranda rights. Well, the short answer to that is they don't have to read your Miranda rights. That does not make it an illegal arrest. Miranda rights apply only to what's known as custodial interrogation. And that basically means, have you been arrested? If you've been arrested and they start questioning you, they need to read you the Miranda rights, and you need to waive the Miranda rights prior to them proceeding with their questioning. Now, the Miranda rights are basically 4 simple rules. 1, you have the right to remain silent. 2, any statements you make may be used against you in a court of law. 3, you have a right to an attorney. And 4, if you cannot afford an attorney, one will be appointed for you. Now, the courts, when they look at whether or not custodial interrogation is taking place, they look at the totality of the circumstances, which is basically factors such as, were you handcuffed, were you taken to the police station, anything else that was done to restrict your movement. So there's no one ironclad rule, especially handcuffing may be a rule of thumb, but sometimes people are handcuffed just to detain them momentarily for the safety of the officer. Now, also, you need to be aware of the fact that you do have to tell the police your name, your identifying information, give them your driver's license if you're driving, whatever ID that you have. In a motor vehicle, you've got to give them the registration of the vehicle, the proof of insurance, things of that nature. Anything that's an identifying question you need to answer. But I suggest you do not waive Miranda rights, because once you've waived them, it's very difficult to exclude those statements in the future. So invoke your Miranda rights. Don't say anything. You should never say anything without an attorney being present or an attorney retained, because once that bell is rung, it's extremely difficult to unring it. Finally, I wanted to give some examples of arrests that occurred or that I made when I was a Florida State Trooper that I did not usually read Miranda rights. One of the most common was driving while license suspended. That was a case that I did not need to question people on in most circumstances, so I wouldn't bother to read Miranda. I'd just arrest them and take them to jail. But, there's no ironclad rule on any particular thing. The most important thing to remember is invoke your Miranda rights if they read them to you. Don't volunteer information prior to Miranda as well, prior to custody as well, because that can be used against you. And as I said before, it's very hard to exclude statements after they've been made. I suggest that you invoke your rights, as I said, and remember, the police or the prosecutor cannot say anything in a jury trial about you invoking Miranda. That would be considered a comment on the right to remain silent and would be a pretty quick mistrial. So, thank you for your time and attention. My website is said it wrong. My website is jrjohnsonlaw.biz. Thank you.